Holy crow. Okay, wait, I got to bring on my guest. We're chomping at the bit to do this. My main man, hashtag 4041, Gene Rossi, 3 decades at the DOJ, 110 federal jury trials, 90 jury trials, supervisor. He's got the Gene Rossi War Room. That's it for your credentials today, Gene. We have got to go into this blockbuster, blew it apart, judge doing the job the prosecutor should have done, eviscerating the defense witness in the case. Holy crow, Gene Rossi, what are your thoughts?
This is pretty bizarre what I'm going to say. That expert is so bad, so horrible.
I know you're going to say.
If I were a prosecutor.
You let him testify.
You're absolutely right, because the cross-examination would be devastating, and I would let somebody else do the cross-exam than that one who did it.
Okay.
But he's so bad, he's so unprepared. And in closing, as a prosecutor, I would say this man is the total con. He's saying that he has PTSD because of police shootings. Sean Bolton didn't even have the gun out of his holster. Are you kidding me, members of the jury? The con continues.
Gene, I swear, I know you know. That's why I interrupted you. That is exactly the thought I had after the judge got doing the job the prosecutor should have done, or maybe the prosecutor had it lying in wait, had the powder dry, wanted the expert to testify for the very reasons you stated, and blow him up in the defense case in the penalty phase, because in the penalty phase, you don't want to play games with putting junk expert testimony before the jury. I, as a prosecutor, would have clearly said, Judge, please, to the extent I can, pretty please, whatever the legal words you use down there in Tennessee, pretty please, let him testify.
Absolutely. I have had a couple cases, not death penalty, where the defense put on an expert that was so ridiculous, so preposterous. I wanted that expert to testify because they look like buffoons. I felt sorry for Dr. Turner because they did not prep him correctly.
Well, Gene, you know, it's funny you bring this up about the penalty, because in a death penalty case I tried where they had a lot of expert testimony, at least 3 of their witnesses blew up so bad in their face on cross-examination and indicated that obviously the defendant had lied to them. They were ill-prepared. You asked me the other week on Flip the Script about the death penalty and my feelings about it a couple of times. You've asked this question, and this is one of the reasons that actually concerned me, believe it or not. I was professionally satisfied that the witness got blown up in front of the jury, but I had to say to myself, wow, is this fair to the defendant?
Yes, I got to tell you, if that Dr. Turner testifies and he gets the death penalty, you may have a habeas corpus where the court agrees there's ineffective assistance of counsel. This is like saying he ate McDonald's hamburgers every day with French fries and ketchup, and that caused his body to react so violently that he killed Sean Bolton. That's how stupid this expert is.
Yeah, and Gene, you bring up really good nuanced points here about how these cases are reviewed on appeal, especially on that ineffective assistance of counsel piece, because as a defense lawyer, given the fact, let's listen to this, Gene. I'm not sure if I got this. You correct me wrong, hashtag 4041. He didn't even know there wasn't a shooting. He didn't even know the cop didn't have his weapon out. And he said that this would affect, you know, his decision. It was based upon those factors. And this judge, I mean, he must have some skills, because he's like kind of one of those frustrated judges on the bench that wants to be a lawyer, but he knew how to ask the right questions. I'd love to know this judge's background.
Yeah, but Bob, I do think the defense, I mean, the government was trying to keep that expert out. I would have made a strategic decision. You want to call that guy? Go right ahead. My cross will be an hour and a half, and he won't be able to get off the stand. He'll have so many cuts.
Well, let me ask you a question, Gene. Getting back to that nuance, we both agree, we both had the same visceral feeling that as prosecutors, we want this guy on the stand because he's going to get destroyed. But going to your point about the habeas down the road, you know, I don't know if I wouldn't take a break for 10 or 15 minutes and a sip of coffee and say, yikes, if this guy gets on the stand, I'm setting up as a prosecutor, even though I want to kill him in front of the jury, it could be the very basis for that ineffective assistance.
Yeah, but here's the other thing. You're damned if you, damned if you don't. What if they make a motion in limine, they keep out this expert, and then on appeal, the appellate court or the habeas court says, you know what, maybe he wasn't really the best expert on the planet, but it's the death penalty phase. You err on the side of inclusion and let the defense put on their case.
Gene, another great point. This is why I love having you on, because you give wide latitude, is what you're saying, wide berth to the defense to put on it pretty much any kind of mitigation evidence that they want, so you don't deprive them of a witness. It's a conundrum. This witness clearly wasn't properly prepared. It's striking, startling. Once again, me and Gene love to break these cases down. We love to support our prosecutors and defense lawyers that are battling it out. But this was no bueno for the defense and created a real matzo ball in this case. We got to go to break. We'll be back on the other end. Okay, welcome back. Hey, Gene, listen. The chat room is blowing up, and I believe rightly so, and probably best done by DMB Mom, I believe it is. The Judge Coffee is what a judge needs to be. This guy, I love watching the good stuff. The defense lawyering was horrible on this point, but this judge, he killed it with regard to his ruling here. Let's start with point one, that it's not considered scientifically reliable in the community. Can you tell our viewers what that standard phrase used throughout the country means as it relates to expert testimony?
On, drugs that cause death, opioids. There's a whole tranche, a whole treasure trove of data to suggest when you take large amounts of drugs, it's going to cause your heart to stop. It could cause you to die. And you have peer review, you have scientific analysis. And when an expert gets up there, they can rely on those scientific tests, the peer review of their colleagues, research projects to make a conclusion. This man, Dr. Turner, I felt bad for him. He admitted there were no criteria, there was no scientific study. He was basically just winging it. And you can't call an expert who gets up there and just wings it. Right. That's impermissible.
So our sophisticated viewers know, in addition to what you just cited, which is the basis for expert testimony has to be something that is scientifically accepted in the community, this guy basically gives them, well, not really. The second argument the judge uses is that factually, he's not even aware that the police officer didn't use his weapon at all, that he was lawfully where he needed to be, that the cop did not exhibit any violence, and basically says the cops here are not on trial. If I allow this speculative testimony, which in and of itself should not be admissible under the rules of evidence, then what we are saying is that when a black man sees a police officer and that officer is not hostile and is doing his job to protect and serve and try to investigate and detain people that are acting illegally, that we're saying it's okay to kill a police officer. Very powerful statement.
Well, Bob, I gotta do this. I want to make lemonade out of lemons. Here's the argument I would make if I were the defense attorney. Not that it's going to win. It's not that the facts of this case fit his exact theory, the Dr. Turner theory. It's that in Mr. Wilbourn's mind, in his subjective state, he thought that when that officer approached the car, that he was going to kill him. Even though Officer Bolton didn't have his gun out, Wilbourn thought in his head that he was going to eventually kill him.
Well, but that is a place, Gene, I'm sorry to cut you off, that is a place where Wilbourn is more than capable of getting up on a witness stand and allocuting that very position, but to ask an expert to opine in something that is not scientifically reliable in the community, and may I add, the judge also noted, to your point, whether the defendant, he never even testified the defendant was in fact suffering from this race-related trauma. He said he may have been. So it doesn't preclude the defendant from putting the defense on. The judges are saying, I'm not going to allow an expert to testify to something that is not scientifically reliable, in which he had incomplete and inaccurate facts, and for which there was not even a finding that, in fact, the defendant was in fact suffering from this new thing called race-related trauma.
Bob, I got it. I'm doing the lemonade out of lemons thing, okay? I'm trying to be a defense attorney, do the best I can.
Well, geez.
What they could have said, Bob, is we have that recording that Mr. Wilbourn said, record this. And the expert could have said that this is consistent with the syndrome that I'm talking about. It's a factor that points towards it. I didn't hear them argue that. And that's what I would have argued if I were going to go this route, which I would not have gone.
Okay, so in the chat room, a lot of people are talking about this. I look at this as like our jurors. Let's go back to that last question that we asked prior to the judge's decision, Gene. Do you feel, I think the judge had a tough call here. I think he made a very, very cogent, articulated, legal and factual argument to support his decision. I don't see this resulting in any kind of habeas because the defense is still capable of eliciting this through the defendant if the defendant chooses to testify. What are your thoughts on appeal?
I don't think it's going to win, but I think the defense put it out there because when they do an appeal, they do have at least something they can grab onto. He kept out our expert. So I don't think it's going to prevail either on direct appeal or that habeas petition that eventually will be on down the road. But you're right. I don't think it's going to matter. He basically nailed it. This theory basically suggests that a black defendant can shoot a white police officer who gets out of his car and approaches. That's it.
Well, I'll take it one step further. I don't even think he identified the officer having to be black or white. It could be any police officer. And he said, then you're just what you said, Gene, then it would give the right for any black man to have the right to kill a police officer lawfully doing his duties, not hostile, not aggressively. And he goes, if the state of Tennessee Supreme Court or the Supreme Court of the United States wants to rewrite that rule, you can, but I'm not. Boy, this was some explosive development in a death penalty case to have your expert excluded. Poor preparation, not scientifically reliable, a judge that gave a razor-sharp opinion with respect to this case. We got to go to break. We'll be back on the other end. Welcome back to the Law and Crime Trial Network. We are in Tennessee versus Tremaine Wilbourn. This case is unbelievable. What happened today, they're in the penalty phase of this case. Right now, you saw some dramatic developments in court. So what's this case? First-degree murder, carjacking, and employment of a firearm with intent to commit felony murder, and convicted felon in possession of a handgun. There you see a picture of him. Those were the charges, and he was convicted of those. In the guilt phase of the case, there's the victim, Officer Sean Bolton. Poor guy, 33 years old, police officer, shot 8 times. There was no violent encounter whatsoever. They just went right after the guy and shot and killed him. We're in the penalty phase right now. I got Gene Rossi with me. Gene, the chat room is exploding. And for those of you who are on Pluto TV and our other OTT networks, I love when I see skills. I call it when I see it, and Gene, we call it when we don't see it. Let me tell you about Judge Coffey. Prior to him becoming a judge, I knew this. He worked as an assistant district attorney for Harris County. You know he's got those prosecutor skills, and that's out of Texas. He was a public defender for Shelby County, so he knows, like us, Gene, both sides of the aisle. Wait a second. He was an assistant United States attorney for the Western District of Tennessee, one of your colleagues out there on the federal side. And as an assistant district attorney general for Shelby County, he was elected to the Shelby County Criminal Court in 2006. So, Gene Rossi, we didn't really have to know that this. Let me just add one last thing. He's a Harvard Law graduate. Okay, Gene, this guy's the real deal. I guess we didn't need to go through all of those credentials to know this guy's been around the block.
You know what's great about him is he obviously has the resume pedigree, Harvard Law School, one of the top 3, if not the best. But he's been in the trenches, and he's been a federal prosecutor, a state prosecutor. But I think what helps him even more is he was a public defender. And when he made this ruling, he was thinking of both sides, like we just discussed. You know, if you keep it out, are you going to have a habeas? So he made an excellent, fantastic record. Phenomenal. I think it's solid. You
know, I just have 2 points to say. You know, I think that one of the strongest assets that I brought to the table as the head prosecutor wasn't my assistant prosecutor years, but was my 12 years of criminal defense. And while I loved all the prosecutors who were career prosecutors, they never dealt with that other side, the pressure points, the issues. They never thought tactically how the defense lawyer's thinking. So even from a tactical point of view, it gives you such a greater breadth of experience. And Gene, I don't know if the same is for you out there in Washington and Virginia and in your experience, but, and I hate to say this, it's just nice to see a really qualified, seasoned judge, because you don't always get that.
No, Bob, and you probably have about 15 judges that you could put in this category. What used to frustrate me is you're doing a criminal case and your judge has had few trials, and all those trials were civil. And they make rulings that are just outright bizarre. 404B, other crimes evidence, other things like that. And you just scratch your head. You walk out of that courtroom and you try to keep your voice low because you're cussing under your breath. And I had that many times.
You know, when I started as a baby prosecutor, Gene, I appeared before lots of judges, tried lots of cases, and I can say virtually every single one of the 9 to 11 criminal judges we had in our vicinage, the smartest man and woman, most talented, most experienced was sitting on the bench. And we learned a tremendous amount from those judges who call you in the chambers, both sides, and, hey, why'd you do this and how come that? They knew how to protect the record on appeal. I think that, you know, talking to my dad who was on with you the other day, and I think you have the same experience, I'm not sure we're experiencing a lot of judge coffees around the country from what we see, but certainly we see some great judges, but, you know, I think there's been some deprecation there. Gene, in this case, in this Wilbourn case, there was an opportunity where the defense wanted to try to make an argument at the end of the guilt conviction that, hey, we'll take life without parole and waive the death penalty and waive the appeals, and the state rejected that after conferencing with the family. To me, it's a no-brainer. I mean, why would the state really give that away if they were truly seeking the death penalty in a case where a cop's been killed?
Well, 2 comments I want to make. One, the decision to accept a guilty plea is always in the hands of the prosecutors. And there have been instances where we accepted pleas, guilty pleas, when the victim's family did not want us to accept the plea. But in this case, I think the prosecutors went to the victim's family said, we don't want you to take that plea. And I think the prosecutors also agreed, let's seek death. This is a person who definitely warrants it. Even in prison, he can't control himself. So if there's ever a reason for the death penalty, and I have trouble with it just like you, I think this man is a poster child for the death penalty.
Right. And, you know, listen, a victim's family has gone this far through this process. And I think we could talk a little bit about, Gene, when you're dealing with victims of violent crime and the families of people who are now deceased and have to be in that courtroom, I mean, the tenseness. I'm thinking of one in particular where I saw a father literally for 2 months of a trial gripping his fist. If he had an opportunity to get at that guy, you wouldn't have needed a death penalty or any other sentence. They go through so much, and they kind of get the feeling that it's always about the defendant but not about the victim, because our Constitution is defense-oriented. So they've gone this far. Why would they give up the ghost, if you will, with respect to executing a guy with this violent background, who, by the way, is charged with riot and all sorts of crimes inside the jail?
Yes, he has all the indicia of someone who has earned the death penalty, sadly to say. He doesn't show any remorse. And I got to tell you, I feel for the defense attorneys. You know, defending in cases like poker, you're given a hand, and the defense attorneys have not gotten one card that they can argue that will save his life. It's pretty sad.
Well, I'll just say this. I don't know what went on. We're always like armchair quarterbacks. But I would crawl under my counsel table. If I called a witness to the stand that didn't even know, the cop didn't even touch his gun, didn't shoot his gun, didn't pull his gun out, and is giving a report 2 weeks before trial, which you know is going to be a problem because the other side doesn't have an opportunity to confront it, with a witness who doesn't know the actual facts of the case and can't testify about a theory that's scientifically reliable. I don't know. I'd be somewhat embarrassed.
Bob, the most egregious thing I heard from that, among others, is Dr. Turner did not talk to the defendant until that morning.
Gene, I mean,
this morning. I find that's outrageous.
EGATs. Hey, Gene, you're the best. Let's go to a break. We'll be back on the other end. I think it got more amazing to me the second time around.
I was just writing down all the negatives against the expert. He didn't know it was a police. He didn't know there was no police shooting.
I'm sorry, Gene. I'm sorry. I got to stop you there because they're going to give us some time. These producers are awesome for, you know. Let's stop there. Correct me, counselor, if I'm wrong. If I get this, he's testifying in a death penalty case for the defense. He presumably has the discovery And did I hear him now say twice when we played it over, that he wasn't even aware that the officer didn't shoot or even touch his gun or attempt to touch his gun? Did he not know that?
He did not know that, and how he did not know that is disgraceful. They could have provided reports or have him read trial transcripts. Bob, as you know, an expert can sit in a courtroom during trial and use trial testimony as a basis for their testimony as an expert. They didn't do any of that.
What's striking to me, though, Gene, is whatever this race relations trauma expert field is, I'm not familiar with it. I'm sure we'll be hearing more about it. And the judge was basically saying, I'm not going to be the first judge that qualifies you as an expert on something you're saying, in my opinion, is not scientifically reliable. And then you can now go to other courts and say, hey, I was qualified by Judge Coffey. That's an aside we didn't even talk about. But he's basically saying, this guy, that I came here and I don't even know the facts and circumstances of what may have led a person to fear the police. He doesn't even know there was nothing.
There was nothing. And my favorite was he essentially said, I'm irrelevant. The judge had that long question, and he basically said, well, your testimony doesn't apply here. He says, correct. So there it is.
Me and you are exactly. I mean, we gotta like open a law practice together. So here's where you are. So what you said about police shootings, which was the basis upon which you have this race relations trauma that he brought out in the direct examination, that none of the facts apply to this case. At first, he's like, I don't know what you mean. Well, and then he said, yes, correct. I mean, Gene, I think this could be one of the most extraordinary debacles of a witness that me and you have ever been on TV and analyzed. And I'm sorry to the expert, but you put yourself out there. I'm sorry to the defense lawyers who get this opinion 2 days or 2 weeks before the trial. And as you indicated, don't even interview the client until that day and can't even say that, in fact, he was suffering from it. But, I mean, Gene, have you seen, and I mean, honestly, is this about as bad as it gets that you've ever seen?
Yes, in 27 years, I've never seen an expert get shot down with such infamy as this one. It was pretty sad. And you know what else is sad? And I'm a former prosecutor, you are too. I'm kind of hard on prosecutors. The reason, my view, the reason a judge took this away and did his own voir dire, and he has a discretion to do that, is he used to be a prosecutor, and he probably didn't feel that the state prosecutors were doing a good job, so he had to take over.
Gene, that's an excellent point. So let's make sure our audience understands what occurred there. The prosecution had cross-examined, and as you've indicated, the judge has to make a record. I think the judge got that this testimony was flaky to begin with, so the judge jumped back into his role, as you see some judges do, especially a guy with mad creds like this judge, and started basically examining the witness and brought out all of that data we're talking about came out from the judge in order to be able to give the opinion to issue the ruling that would survive appeal. Judge Coffey, congratulations. We have mad respect for you. This is the Wilbourn case. We're going to go to break, and we'll be back on the other end. Hang in. Even though it wasn't right to do, he did it. Do you mitigate that a little bit? Because people are asking for this teacher to go to jail. Is that too much?
Well, I got to say, based on what I saw in that video, I don't think jail is inappropriate. I don't think he should go away for 20 years. But you have to send a message. You can't do this. He took a cell phone, which could be a deadly weapon, and you don't know if that could have killed that child. So I think jail time would not be inappropriate. He obviously has to lose his job. He cannot remain as a teacher in the foreseeable future, if not for a very long time.
Right. Well, you know, listen, that's why I love these top crime stories, because as prosecutors, these were the cases that would come in. And the discretion that you have as a prosecutor can be wildly different from place to place. Some may just say probation. Some may say state prison time. Some may say probation with some county jail time. You know, some may say a diversionary program. Really hard to say, but that's why it's a tough job to make these calls and to defend these cases and try to do the best you can to mitigate the damage of the charge. So obviously not a good day for this teacher. Gene, You know, we talk about this before. Nothing is more exhilarating than when you're in a case of significance, like the Tremaine Wilbourn case, man accused of killing a cop, death penalty case, when you're told by the sheriff's officers and the judge, you may be out in the hallway, you may be getting a candy bar, you may be down in the cafeteria, you may be hanging out in the courtroom, you're just waiting, waiting, and then all of a sudden they say, the jury's got a verdict. Let's go to the Wilbourn verdict.
The jury found the defendant guilty of first-degree murder as charged in count 1 of the indictment. Count 2, we, the jury, find the defendant guilty of carjacking as charged in count 2 of the indictment. Count 3, we, the jury, find the defendant guilty of possession of a firearm during the commission of or attempt to commit carjacking as included in count 3 of the indictment. Count 4, we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 4 of the indictment.
Okay, welcome back. So, you know, what are your thoughts there, Gene, about, you know, we kind of laugh to ourselves that they do it too sweet down there south. We just had one in Texas they took in 30 seconds, I believe it was. But this was not something that was unpredictable given the gravity of this case.
No, I don't think anybody on that defense team, including the defendant, felt that he had a chance of even a hung jury. Bob, I got to go back. The style they have in Tennessee and Texas, in the Eastern District of Virginia, Alexander Federal Court, the jury comes out, my heart's outside of my chest, and the judge looks at the verdict form, hands it back to the deputy clerk, and the deputy clerk has defendant stand and face the jury. And it is an incredible minute and a half. You almost faint. You really do. Here it's like, okay, you're guilty. What's the date for sentencing, prosecutor? You know, it's sort of almost an aside.
Yeah, and you know, and you also look at the amount of time, the verdict. I believe this one was close to like 2.5 hours. Gene, I got to tell a funny story because I know our audience loves when we tell little anecdotal stories. We had 2 juries going out on murder cases that I was trying as a young prosecutor, and this one prosecutor was so cocky that he was going to win the case, and he said, my jury's coming back faster than your jury. And I'm like, man, my jury's coming. So we actually clocked when the jury charges got done. We had one person that was running around, and within about 2 hours, they come knocking on the door. They have a verdict in mind, guilty. And then I go over and I run down the courtroom where the other guy was. Jury didn't come back. 2 hours, 4 hours, 6 hours, 8 hours. We all go to the place where we normally would go on a Friday to get some Coca-Colas and 7-Ups and discuss the week. And the guy's not, he's in there, he's all slouched over in that place. And I said, what happened? They came back not guilty. So you never know what a jury's going to do. It's professionally satisfying, but when they come back fast, it's nice too.
Oh, yeah. I have a buddy, Bob, that he's still a federal prosecutor in SDNY, New York. He had a jury trial where they deliberated in Connecticut for almost a month and a half. A month and a half.
Yikes. That's extraordinary.
They came back hung. One defendant was guilty, but the other was a hung. Can you believe it?
Oh, my. How long was that trial, real quick?
The trial was about 3 months.
Oh, wow. Wow. That's amazing. All right, guys, listen, we're in the Wilbourn case. I'm great to have my friend Gene Rossi with me. Guy knows what he is talking about, just like the judge knows what he's talking about. And this all surrounded this Dr. Turner today, these amazing developments. I'm sorry to keep going back to it, but I have never seen, in my opinion, and I think Gene's too, anything is riveting with regard to an expert in a courtroom, and it's really worthy of going through it again and watching how the defense case in the penalty phase for Mr. Wilbourn has basically, in my estimation, fallen apart. Let's go to it.